court will be handed in undisclosed locations after the incident. The court issued a part of orders in the first instance as follows. 1. That pending the hearing and termination of this application of the parties and orders hereby issued, directing the respondents to immediately disclose the whereabouts of the second and the fourth petitioners to the first petitioner. That pending the application, the hearing and the termination of this application of the parties and orders hereby issued, directing the second respondent to immediately release or produce the second and fourth petitioners and court in the court of competent jurisdiction to make such orders as may be appropriate to uphold the rights and fundamental freedoms of the second to the fourth petitioners. 4. That the matter was then put for mention on Monday, the 26th of August 2024 at 10 a.m. to confirm compliance. During the budget session held on the 6th of August 2024, on the advocate for the petitioners and commander here, she informed the court that the orders made on 29th of August 2024 were duly served as respondents by the affidavit of service. However, there was neither appearance by the writing of the respondents or responses to the habeas corpus application. There had been no compliance with the orders either. That necessitated the court to provide respondents in which it directed that, pending the institution of the child is if any, the court now directs the unconditional release of the second, fourth petitioners by the first respondent. Number 2, that physical service of the order be effected by close of business that day. And number 3, that summons to issue to the first respondent to appear in court on the next motion to explain why the habeas corpus issued by the court were not complied with. The matter was fixed for the 9th of September 2024. On the morning of the 9th of September 2024, the Attorney General, the DPP, and the Director of Public and the Director of the Service, the Inspector General of Police, and the Director of Criminal Investigations appear in group counsel. None of them are required to respond to the application, and the orders of the 23rd of August are not being complied with. The Inspector General of Police, who the court and summoned, did not turn up. The court postponed the matter to 3 p.m. Office court attendance of the Inspector General to explain them why the habeas corpus are there untrue. The afternoon came and passed. The Inspector General of Police did not attend. The court was informed that he was out of office on official business. With the nature of business being reviewed in a workshop he was attending in Mombasa on budgeting that particular morning. In the afternoon, the court was told that he was engaged in security operational duties in court operation. That matter was rescheduled to 5th of September 2024 at 10 a.m. as the court was keen to establish why the habeas corpus orders did not be executed with respect to the production before the court of the release of the second and fourth petitioners. Ms. Mangu, who appeared for the Inspector General, explained as follows when pressed to explain the apparent persistent disregard of the court summons by the Inspector General of Police. The Inspector General of Police has not said he is not coming. He is requesting for another date because it is our position that the second and fourth petitioners are not with the police. The Inspector General of Police is requesting another date to appear because we cannot his officers with the claim. The Inspector General is requesting another date to appear in court, and after holding some brief constitution, Ms. Mangi said the Inspector General of Police will come on Monday 9th of September 2024. The officers of the Inspector General of Police are here and have confirmed his availability on Monday, considering his work, and his end of work. The court, after this brief session, fixed the matter to 8 p.m. on the same day. Despite the court convening, the Inspector General did not show up. The court finally and directly agreed to give the final opportunity to the Inspector General of Police to attend court, coinciding with the date that counsel for the Inspector General will be available. This was after the made some brief consultation. The date was Monday, the 9th of September 2024. On that day, the court distressingly wrote, and I quote, the stream of reasons and excuses by the Inspector General of Police are definitely bound to run out. To proceed at this juncture and this to make a finding of contempt of court may be seen as premature in a grave matter of contempt of court, which is a form of criminal sanction being an offense against the administration of justice. Our constitution requires a high threshold of criminal matters. Reluctantly, the reasons for an attendance today must be considered. It is thus necessary that I postpone these proceedings to Monday, the 9th of September 2024. The Inspector General, having earlier indicated his availability on this particular day, should have no further excuse but to comply and attend the court physically at 10 a.m. so that the court can put this matter to an end. Due to the persistent non-compliance with both the court summons as well as failure to comply with the orders of the 23rd of August 2024, the court opined that it was a case of contemptuous conduct that the Inspector General needed to find, even as he said the date for the 9th of September 2024. That date came and passed through. The Inspector General did not turn up, but he made a last-minute attempt and sent his Deputy Inspector General in charge of criminal police to appear on his behalf. The court rejected the arrangement, noting that the open defiance of the court summons had metamorphosed to contemptuous conduct and was now a personal matter that and to be directly Section 3. Following the failure to attend court or comply with the order of 23rd of August 2023, the court entered a finding of guilty for contempt of court against the Acting Inspector General of Police on the 9th of September 2024 and deferred the sentence to Friday, the 13th of September 2024. The sentence. As part of considering the appropriate sentence, I have to look at this matter from a constitutional perspective. The preamble to the Constitution reflects the commitment to the people of Kenya to attain a number of aspirations. One of them is statement number 6 of the preamble, which states as follows: recognizing the aspirations of all Kenyans for a government based on essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. The Constitution under Article 2, Sub-Article 1 proclaims itself as the supreme law of the land that binds all persons and all state organs. Article 3 obligates every person to respect, uphold, and defend the Constitution. It matters not whether they are mighty or low. The Constitution further proceeds to specify the national values and principles of national governance that bind all state organs and all persons whenever they make and implement public policy decisions, enact laws, and interpret. Among those values and principles are that contained in Article 10(2)(b), which as human rights, the rule of law, among others, whereas Article 10(2)(c) are the principle of accountability. In matters of national security, Article 238 provides that the principles which shall apply and include the following: that national security is subject to the authority of the Constitution, and the national security shall be pursued in compliance with the law and with the utmost respect for the rule of law, democracy, human rights, and fundamental freedoms. The rule of law principle is thus a common law that the Constitution every demands in almost every function to ensure that every person is held accountable to the law. It ensures that equality of all before the law and prevents arbitrariness. The task of the court is to ensure there is a fair balance by applying the law when disputes arise either between the state and its citizens or between citizens themselves or between state organs or agencies. Neither a state organ or its officers or individual is above the reach of the law, as the Constitution in Article 2, Sub-Article 1 declares. The power of the court to adjudicate disputes according to the law is a delegation by the people pursuant to Article 159, which states that judicial authority is derived from the people and vested in and shall be exercised by courts and tribunals established by under the Constitution. The power is exercised subject only to the Constitution and the law, and is not subject to the control or direction of any person or authority. Article 16. The following extract from the South African Constitutional Court in the case of Secretary of Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud in public sector, including organs of state, Zuma and others, sums up the position of court orders in a constitutional democracy. The court held: orders and decisions issued by a court bind all persons to whom and the organs of state to which they apply, and no person or organ of the state may interfere in any manner with the function of the courts. It follows from this that disobedience towards court orders or decisions risks rendering our courts impotent and judicial authority a mere mockery. The effectiveness of court orders or decisions is substantially determined by assurance that they will be enforced by all and sanity, including organs of state. In doing so, courts are not only giving effect to the rights of the successful litigant, but also, and more importantly, by acting as guardians of the Constitution, asserting their authority in public interest in the court. In the same application, Dr. Fred Matiang'i, the Cabinet Secretary, Minister of Interior and Coordination of National Government, versus Miguna and 4 others, the Court of Appeal affirming the power to punish for contempt held as follows: when courts issue orders, they do so not as suggestions or pleas to the persons at whom they are directed. Court orders issued ex cadenza are compulsive, peremptory, and expressly binding. It is not for any party, be high or low, weak or mighty, and white, regardless of his status or standing in the society, to decide whether or not to obey, to choose which to obey and which to ignore, or to negotiate the manner of his compliance. This court, as must all courts, will deal firmly and decisively with any party who remains to disobey court orders, and will do so only to preserve its own authority and dignity, but most to ensure and demonstrate that the constitutional ethics of equality under the law and the upholding of the rule of law are not mere questions but present realities. End of quote. The court entered a finding of guilty. This court entered a finding of guilty on the 9th of September 2024 after all efforts according to the contempt to find the contempt were ignored. This was to ensure its authority and dignity, which and 5 others versus Jericho Tea Factory Company Limited, acknowledged that courts have inherent power to punish for contempt to vindicate their authority, besides pinpointing the source of authority of Kenyan courts to punish for contempt after declaration of unconstitutionality of the Contempt of Act 2016. The court stated, and I quote, courts possess the inherent power to enforce compliance with their lawful orders through sanctions imposed through contempt of court. We note that the Contempt of Court Act, having been declared unconstitutional in Kenya, Human Rights Commission versus Attorney General and another 2018 EKLR on November 9, 2018, the instructive provision remains Section 5, subsection 1 of the Judicial Act, which grants the High Court and the Court of Appeal the power to punish for contempt. It provides the High Court and the Court of Appeal shall have the same power to punish for contempt of court as for the time being possessed by the High Court of Justice in England, and that power shall extend to upholding the authority and the dignity of subordinate courts. End of quote. Today, this court is required to pass sentence for contempt of court. The principles to be considered in determining an effective sentence in a contempt of court matter were considered by the South African Constitutional Court in the Jacob Zuma case, where the court discussed the coercive versus punitive conduct and explained the difference between the two approaches as follows. There is a distinction between coercive and punitive conduct, which differences are marked and important. A coercive conduct gives the respondent the opportunity to avoid imprisonment by complying with the original order and desisting from the offensive conduct. Such an order is made primarily to ensure the effectiveness of the original order by bringing about compliance. A final characteristic is that it only incidentally vindicates the authority of the court that has been disobeyed. Conversely, the following are the characteristics of a punitive order. A sentence of imprisonment cannot be avoided by any action on the part of the respondent to comply with the original order. The sentence is unsuspended. It is related both to the seriousness of the default and the contumacy of the respondent, and the order is influenced by the need to assert the authority and the dignity of the court to set an example to others. The court then went ahead and found that the conduct of the contender was human and made it undesirable to benefit from coercive order, reasoning as follows. A coercive order would be both futile and inappropriate in these circumstances. Coercive committal, through a suspended sentence, uses threat of imprisonment to compel compliance. Yet, it is incontrovertible that Mr. Zuma has no intention of attending the commission, having repeatedly reiterated that he would rather be committed to imprisonment than cooperate with the commission or comply with the order of this court. Accordingly, a suspended sentence being coercive order would yield nothing. End of quote. The condemner, in this case, was accorded every opportunity to fight the content to the extent that attending a workshop in Mombasa was more important than obeying a court summons intended to seek an explanation of the whereabouts of the second Sudan petitioners, last seen on the 19th of August 2024, the date of alleged objection. Nevertheless, I took note that on the last date, the condemner attempted to bring in his deputy to explain the position with regard to the summons. The reverent defiance of court orders brings impunity, particularly when it is done by those entrusted with public power, as it is inconsistent with the purposes and the objects of the Constitution. In passing this sentence, I am conscious that it is directed to the highest ranked police officer in this country. He is still in office. That might pose a challenge in the enforcement of the order, since in police service, seniority is highly regarded. That, however, cannot deter me from pursuing and standing firm in the defense of the aspirations of Kenyan people who decided at the time of enacting this constitution to have a country that is governed by adherence to the rule of law. Part of the oath of office that I took as a judge states as follows. I will at all times, and to the best of my knowledge and ability, protect, administer, and defend this constitution with a view to upholding the dignity and the respect for the judiciary and the judicial system of Kenya. End of quote. The constitution of this country is supreme, and Article 2.1 reiterates that by stating that it binds all persons and all state organs. No man or state organ of authority is above the Constitution. The Constitution command through this court is that I uphold the rule of law by protecting the integrity of the judicial system. The significance of this sentence today is to vindicate the cherished principle of the rule of law in our constitutional democracy by restoring the dignity and the authority of this court in public interest. Borrowing from the South African Constitutional Division, the contemner shall serve sentence as follows. The contemner, Mr. Gilbert Masengeli, is sentenced to 6 months imprisonment. Mr. Masengeli is ordered to submit himself to the Commissioner General of Kenya Prisons to ensure that he is to be committed to a prison facility to commence serving sentence of the imprisonment imposed. In the event that he does not submit himself to the Commissioner General of Prison service as ordered, the Cabinet Secretary for the National Interior must take all steps that are necessary and permissible in law to ensure Mr. Gilbert Masengeli is committed to prison to commence serving the sentence imposed on him. The court, nevertheless, finds it desirable to impose this sentence as a coercive order as opposed to a punitive order. In that regard, Mr. Masengeli may avoid serving this sentence, and therefore, in that regard, the court shall suspend this sentence for 7 days only. The acting Inspector General of Police can redeem himself and comply by availing himself before this court in person to answer to the issues he has been avoiding in the fall. The sentence shall automatically become effective.